Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So it's time we have an update on the GWACS case because there's actually two big developments in the case. Now, if you haven't been following this, or if it's been a while since we had an update on this one, a brief recap. So GWACS is officially a gun company. It's GWACS Armory. However, they don't seem to be making any guns at the moment, and people involved in GWACS have made some very heavily anti-gun statements, particularly about the AR-15, which is the article in question in this lawsuit. It's an AR-15 lower. So that's a whole weird thing, and they're suing a company, KE Arms, as well as some other people, and the issue is over this polymer monolithic AR-15 lower. Now, GWACS initially was suing for various violations of intellectual property. And the problem is, and the reason why I got started covering this is because it's hilarious, because there just doesn't seem to be any intellectual property here. They're suing because, or they started suing saying you're violating our patents, but there aren't any patents. And yeah, so I've said before that the people I thought GWACS should be suing is not KE Arms, but actually their lawyer, because they bought this company to get this stuff and they said we're buying all intellectual property, and they never actually checked to see whether any patents actually exist. They just kind of assumed patents must exist. But when you buy all the intellectual property from a company, all you get is the intellectual property that actually exists. It doesn't magically create intellectual property just because you incorrectly assumed there must be patents. Sorry, these are not patentable. So let's get on to the updates. And the first of these updates happens to be interesting in terms of its timing, because it is filed February 3rd, 2025. Yep, February 3rd. Now, the trial for this case started February 10th, 2025. So this is filed a week prior to trial. And we're not going to go through it in its entirety because we're just going to comment on it enough to sort of talk about what's going on and why they're filing it and why it's dumb. So what they're asking for is realignment to the parties and / or joinder of Kinetic Energy Arms and R&M Holdings. So they want to add two companies to this lawsuit a week prior to trial, which is crazy. Right? How do you add parties a week prior to the trial? It's nuts. So what are they doing? What's going on here? They're saying Russell Fagan, the former head of sales and marketing for KEA and lead on the KP15 project for KEA, is the sole member of Kinetic. Okay. And they note that KEA's assets were sold to Fagan, an insider of KEA. And they have some things about the timing of the FFL, which are not great information there, but basically they're saying that they think that Kinetic is an alter ego of defendant and that the transfer was to avoid any judgment entered in this matter. However, when you look at the timing of this, it appears that the timing is around 2023 or 2022. And so they had lots of time to do this. They had lots of time to get upset about this, and they decide to do it a week prior to trial, as opposed to like figuring all this out ahead of time and dealing with it then. So they also, it gets a little even weirder. They have allegations of fraud, and they have allegations of that it's a mere successor company, but it gets even weirder when you start getting to R&M. So R&M, they've also said they want to add, and their basis for adding R&M is super thin. GWACS currently cannot ascertain what assets R&M received or the nature and extent of their involvement with KEA. Maybe you should ascertain some things before you file a legal document. That, you basically just said, we're filing this on pure speculation. However, the time frame surrounding R&M's FFL licensure at the same location as KEA and Kinetic raises questions as to R&M's involvement in KEA's attempts to hide assets. You don't come to the court with questions. You come to the court with answers, and you tell the court that you need remedies based on those answers. But you can't just say, we don't know what's going on, so we want you to add these people to the lawsuit based on we have questions. No, you don't get to do that. They say it is believed R&M may have received a portion of KEA's assets, but of course you'll note an absence of evidence here, an absence of citation. Who believes this and why? Do they actually have a good reason to believe it? Or is it, crazy GWACS things? Because if it's crazy GWACS things, the court's not going to put up with that. To the extent R&M is engaging in the sale of the KP15 and KP9, it would be liable under both theories asserted by GWACS against KEA. What extent is that? Because you don't have any evidence that you're noting here that they're selling the KP15 or the KP9. So to the extent, you need to actually tell the court what that extent is, because if that extent is 0, then your claim is ridiculous and laughable. And yeah, so to the extent R&M received assets from KEA under circumstances similar to Kinetic, it would also be subject to successor liability as discussed supra. Now, I hate supra because it's unnecessary Latin. You can just say above. Above is a perfectly good word. Same number of letters. You're not even saving printer ink. And all you're doing is just using unnecessary Latin because you think it sounds cool. Latin is not cool. Sorry. So yeah, they asked to add these people or make them liable to the claim, which, a week before trial is a bold move. But KE Arms has a response, and we're going to cover that briefly as well, because KE Arms' response is to go, wait a minute, you guys are engaged in some absolute BS. So here's the response. Defendant KE Arms hereby submits its response to plaintiff's position on realignment and joinder. And they say, not only is this request clearly untimely, i.e. it's a week before trial, but plaintiff's sole basis for seeking substitution is its interpretation of statements made by KEA during the parties' confidential settlement conference. Now, the thing is you can't use stuff from the confidential settlement conference for anything. You just can't. It's a confidential settlement conference. It's intended to have the parties able to speak freely, but you can't use it. And so they note that. They say, in light of long-standing and universal public policy encouraging candor during settlement conferences, the local rules of this court explicitly render the factual basis for plaintiff's motion unusable for any purpose outside of enforcement of a settlement, and therefore to preserve these public policies and the court's own neutrality, the court should decline to even consider plaintiff's motion. They also note, moreover, the plaintiff's argument does not even give rise to a basis for substitution under the rules of civil procedure, and substitution would be nonsensical given the undisputed fact that KEA was the party who signed the contract at the heart of plaintiff's case. For all of these reasons, the plaintiff's request should be denied. The heart of their case at this point, it's been cut down from an argument of intellectual property to an argument that they breached a non-disclosure agreement. And this breach of the non-disclosure agreement is about things like, we told you that we were almost out of money, and we told you that you were, that this is a place that we were going to put a quick detach mount and so forth. Okay, so how does the court deal with this? Well, the court deals with this in hilarious fashion, which is they just respond to it with a minute order, which is rather than writing up a full formal order, they just put on the docket an order that's just kind of quick and dirty, and I will read it to you here. Minute order by Judge John D. Russell. The court has reviewed the motion for joinder of parties and the response thereto. The motion is denied. The court shares the concerns raised by defendant regarding the use of confidential settlement information. But even if plaintiff had obtained the information set forth in its motion through other means, which of course might be hard for them to establish, neither joinder nor substitution would be appropriate at this time, i.e. a week prior to trial. It's crazy to try to add people to a trial a week before the trial. The court assumes that plaintiff seeks joinder under Rules 15 and 20 of the Federal Rules of Civil Procedure, and they note the court assumes this. That's shade from the court. That's the court mocking the lawyers, because it's like, you should actually tell us what rules you're using. Like, don't just make us assume. But plaintiff did not address those rules, nor did it provide evidence to support its contention that joinder is appropriate 1 week prior to the trial of this matter. The court is like, yeah, you kind of suck at this. And you know how I said previously that maybe they should sue the lawyer instead of KE Arms? I think it's the same lawyer on the file, which should be a problem, but they don't seem to be finding that to be a problem. Based on the information presented by the parties, plaintiff knew of the information allegedly supporting its motion over 6 months ago. Whoops. Yet plaintiff does not provide any justification for its decision to wait until the pretrial conference to seek leave to join additional parties. The court concludes that the unexplained, undue delay would prejudice the defendant and unnecessarily delay the trial of this case, which has been pending for over 4 years. Assuming the motion is brought under Rule 25C, which is also not discussed by the plaintiff, that is the court saying, maybe you want to do some lawyering, Mr. Plaintiff's lawyer. The court notes that it does not appear from the motion that the service requirements of that rule have been satisfied. There's rules to follow. You didn't follow them. But even if the proposed new parties had been properly served, i.e. you want to add these new parties, you have to actually serve them with notice that you're planning on trying to add them to a lawsuit, the court would decline to exercise its discretion to substitute parties in this case. So even if you did that right, we would still say no. This matter is set for trial in less than a week. There's been no showing that realignment of the parties would change the outcome of the case, facilitate the trial, or accomplish anything other than delaying the trial and increasing the duration, cost, and complexity of the matter. Accordingly, the motion is denied. The court did not take it very well that they wanted to add parties to this case at the last minute. Now, as I mentioned, trial began February 10th, and I had originally planned on going there, but then the world got political and chaotic, so that no longer made any sense. So I was not able to go there to report in person. But I was able, through the use of, resources, to figure out what has happened, because the trial is now over. This is the second update, which is that the trial of GWACS versus KEA is over. It's done. And GWACS had a number of claims that were still outstanding. They were allowed to put a number of questions to the jury. And the jury had one answer for all of those claims, which was, GWACS, go fuck yourself. That's not how they put it, of course, because they would have just ticked boxes on a jury form, but GWACS got completely shut out. They have not won on any of their issues, and yeah. So, KE Arms is the winner in the whole GWACS versus KE Arms case. GWACS has, clowned themselves throughout this, and now it's over, it's done, unless they decide to appeal, which, oh God, why? But, they've been throwing good money after bad on this. Maybe they'll realize that, hey, the issue was actually our lawyer told us, we thought we were buying intellectual property. Shouldn't our lawyer have actually identified through due diligence that there wasn't any? But, if this case has been going for 4 years, the limitation period on that has probably expired. I'll leave that for... GWACS can solve GWACS legal problems. But at least at this point, it appears to be over and done. Which means maybe I'll look into trying to buy a KP15. I can do that. So, yeah, I thought I'd give you guys this update, which is GWACS. It's over, and the righteous have prevailed in this case. So, thank you guys for watching. I hope you found this to be interesting or educational. I'm going to try to find more information on this. I'm going to try to reach out and see if I can get some more details to share in a future video. But I thought I'd give you guys this info right now. Hopefully you guys will, find this to be interesting, but I'm like, okay, good. I am glad that it's got a happy resolution because I thought GWACS was really being quite silly on this one. So thank you for watching. I want to thank my Patreon supporters. There's a link to the Patreon below. At the $50 level, that is Purple Dragonair, Cielo, Angela Skelton, PJs Forever, Canadian Coalition for Firearms Rights, the Canadian National Firearms Association, the Canadian Shooting Sports Association, and Bottle Shock in Oz. And at the $20 level, we have Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, Marvin CZ, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.